Zero.
Present.
Vic Peretta.
Present.
Doug Avery, absent. Dave DeLaylis.
Present.
Lou Ferrara.
Here.
We have a quorum.
Not present.
We have a quorum, let's stand, say the pledge of allegiance. Motion. A moment of silence.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. We're now in session. Mr. Foster,
I will.
you want to explain why we have this meeting so quickly?
I want to thank the board for this special meeting. I want you to know that as I had previously informed you, I sent each one of you a copy previously of a transcript of proceedings before Judge Doyle, and I also sent you at that time a proposed order resulting from those proceedings, which has now been signed. It was signed yesterday in my presence by Judge Doyle in Rochester. Emil Bovey, myself, Peter Walsh appeared and spoke with the judge in chambers, and he has directed, as the order I sent to you, the following. He has indicated in his findings that he is, well, let me go back. There was a request made by Mr. Bovey to have the town attorney disqualified from representing the HPC. That application was denied. On the other hand, he said there may be the appearance of different roles between the goals of the HPC and the goals of this board, which may lend itself to the appearance of an impropriety or the appearance of more appropriately of a conflict in interest. To avoid that, he is according them, the HPC outside counsel, payable by the town. You may recall the other night at our meeting, a question came up, was fielded by one of the people who said, why can't the town attorney represent the HPC? As town attorney, I have represented them. I filed an answer on their behalf. I have appeared in court on more than one occasion, and at this point they have indicated they want a second or another opinion as to some of the issues. So what Judge Doyle is doing is he is allowing them to have that opinion in this particular case only. So they're not hiring counsel for the HPC for whatever. He is directing that they have counsel, and in the transcript that I forwarded to you, you can see that he put restrictions on it by asking that counsel form and advise the court of their plan, what they intend to do, the scope of their services, and the cost. He asked that cost, because it's for a municipality, be tempered, which in plain language means a better rate, if you will, and that's common. Most large law firms do tender a lower rate to a town in most cases. In this particular instance, he wanted conforming resolutions to say that we would do this. He has ordered that it be done. I have a copy of the order here, and I've sent all of you copies of that proposed order. This resolution reads as follows. It's a resolution confirming the retention of outside counsel for HPC pursuant to court order. Whereas by order of the Honorable Daniel J. Doyle, Seneca County Supreme Court, dated November 8, 2018, the Seneca Falls Town Board has been directed to provide counsel for the Heritage Preservation Commission. And whereas the Seneca Falls Town Board previously received an engagement letter from Hancock Estabrook, Wendy Marsh of Council, setting forth the billing rate. And whereas the aforementioned order sets forth additional parameters on the scope, rate and details of the engagement of counsel, which are incorporated herein by reference to that document. And whereas pursuant to said order, the town attorney has not been disqualified from this within matter, but rather counsel has been appointed to avoid the appearance of any impropriety or conflict. And now therefore be it resolved, Hancock Estabrook, specifically Wendy Marsh, is duly appointed as counsel for the Heritage Preservation Commission in connection solely with the matter of the Peter Koch application presently pending before the board, and further pursuant to the further restrictions of the court's oversight of fees, scope, and billing. In essence, the court is saying that it will review any billings to assure that there's not there isn't more work here than is anticipated by what is necessary for this particular action. All counsel were present then. This resolution is somewhat immediate because the judge has directed a phone call. It would have been for Monday. Monday is a holiday, Veterans Day. So the phone call is set for 9 o'clock on Tuesday morning, and he wanted this passed prior to her appearing so that she does have the authority to appear. She has sent us a letter previously. I note it's dated August 25th of 2017. I think the 17 is a mistake. It should be 18, but it's an engagement letter indicating that she would be billing at the rate of $250 per hour, which is a lower than normal rate because it's a reduced hourly rate, and the associates' rates have been reduced as well. It's basically for the purpose of this particular case, and the letter so states that it's relative to the pending Peter Koch application related to 201 Fall Street. So those are the issues that are involved. The resolution is on to simply conform to the order that was directed by Judge Doyle, and I would note in there he specifically orders the town of Seneca Falls is directed to authorize independent legal counsel to represent the HPC concerning this proceeding and the applications pending before it by the petitioner in Circle K. And he also further indicates that there is not any type of disqualification of your town attorney, but at this point there will be some type of resolution of the matter. So that's where we stand at this point. I just want to see if I can read from this one other. It is further ordered to judge and determine that in consideration of these determinations, the application to disqualify the town attorney from representation of the APC concerning this proceeding pending before the court is denied. So he is not saying that anything has been, there's no reason to disqualify counsel, but he's giving them the benefit of the doubt by having them get a source of legal information from another source as well. And I think honestly the issue is there is historical preservation. The Heritage Preservation Commission has as one of its stated goals to preserve properties, and one of the avowed goals of this board had been to encourage development, and not surprisingly, those two things may sometimes clash when they happen in the same location. So that's the reason, that's the background. This resolution basically is to confirm that this board has in fact hired her in accordance with his order, and upon it being approved, I will have Nikki provide me with a certified copy, and I will upload it by e-filing to this case so that it is on the court's record as an e-filed document. And then Tuesday morning at 9 o'clock, we will have this conference. A November 30th, 2018 hearing is expected, and that will be in Waterloo with regard to the issues before the court. So that's where we stand at this point, and I would accordingly ask the chairman to subject this resolution to approval by the board, and I would ask my board members to approve it.
Okay, does anyone want to make the motion under new business?
So we're being directed by a court
We are.
to spend more money for outside attorneys to litigate on behalf of the town against the town.
That is true. Well, I won't say, Lou, against the town. I will say that he is appointing counsel for the HPC to carry out its duties as an organization, and to have the advice of someone other than the board's attorney so as to remove any taint or any suggestion that somehow my goals as attorney for the town board would somehow impact on the goals of that organization. I don't necessarily agree with that, because as the board knows, I also represent the planning board, I've represented the zoning board, I've represented this town board. On occasion, I have to deal with the Board of Assessment Review. I think that's why the judge determined that there was no reason to disqualify me, but given there are some unique questions in this particular case that need to be addressed, and I will tell you that one of the defenses that Mr. Koch has put forward in his Article 78 proceeding is that back in 2013, while this board was not this board, but a previous board was represented by other counsel, and while one of the other counselors who's present now, Mr. Bovee, was actually a member of this board, there is an allegation that by Mr. Koch that with the changeover from the village to the town, that the local law that was filed with the New York State Department of State was in error, and therefore he is challenging whether the entity known as the HPC exists or is properly constituted, meaning it's whether its members are duly appointed. So he's challenging that, and rather than have me as the town attorney have to take a position one way or the other on that issue, that board feels that they want their own counsel to make that argument. So if the court should rule that this wasn't properly filed, it was supposed to have been filed before December 31st of 2013, it never got filed until March of 2014. If Mr. Koch is successful in his argument, he is not before any type of board that has any authority, in which case his application would be transferred to the planning board, and he would simply pursue that avenue.
So that being said, is this a one-time appearance for this outside counsel in court to show up that day?
it could be if on the 30th, if the court made the determination that Mr. Koch was correct, I'm concerned because it has grave consequences, not just for the HPC. It has grave consequences for all of our statutes, rules, regulations, guidelines, other boards, because the only thing that I can find that was filed with the New York State Department of State is a 7-page document which simply refers to those things. And you all know what a code book looks like. You all know what other documents look like. This would have been a huge filing, and it appears as though we have a 7-page document. So if that is, I can't speak for the court. Obviously, I'm trying to resolve the matter, and I think it perhaps may be resolved. It seems to me what has been lost in the perspective is we're arguing over a building that is, I'll say, in sad shape. I'm not saying that it can't be fixed or whatever, but it's a sad shaped building. So hopefully we reach a resolution, but I think you can see that if the HPC is saying, no, that's not the case, we really do exist, and I have to look at this from the viewpoint of the town, I want to be able to argue for the town's position. That's my job here.
May I ask a question?
No, you can't, ma'am. I'm sorry. You
No,
can't
I'm
at
sorry.
this point.
I just wanted to know.
So
what
the
HPC
bottom line is, what we have to do is make a decision, is to have this other council come in and put whatever argument they want before Judge Doyle. So, Lou, could this be a one-time appearance? It could be. I will also go to the opposite end of the spectrum and say, from this attorney's perspective of what I'm finding with the Department of State, there's a phrase that sends fear through the hearts of judges. And that phrase is case of first impression. Case of first impression means the courts have never quite ruled on something before, and that makes it very, very, very serious. So, if that's the case, I have a concern here that the presence of outside counsel may not be a one-time appearance.
They'll have a carte blanche in our checkbook.
That's a way of putting it, I guess, in street terms, yes, and I can't disagree with that, but I'm concerned, and because of that, I have, before the November 30th appearance, I want to have a conference with my board to decide. I don't want to lose sight at the end of the day, before we get into all this legal rambling. I'd like to keep the perspective that we are talking about a building. And I think it would be prudent to have a discussion, a realistic discussion about the building prior to digging holes in the ground and trying to figure out what the issue is until you get to the bottom and you realize that you have to come back and talk about the building. So I'm very concerned, and frankly, I agree under these circumstances with the court saying we're going to have another attorney advise them, because at some point my goal here is to also apprise my board of what I feel we should do. And indeed, there may be differences of opinion at that point. So the court's doing the right thing.
What bothers me is you're a town employee.
Yep.
You represent the town board.
Yep.
You represent our committees.
I do.
And this particular committee isn't happy with your representation, and I don't understand why. From what I've read, you've answered everything in a timely manner.
Yes.
You've appeared every time as counsel you were supposed to.
Yes.
I don't know how it got to this point where We have to go outside of the box now.
I can tell you, what happened is this. I had to file an answer to Peter Walsh's Article 78. I prepared an answer because both the town and the board was sued. In other words, the town and the HPC were both sued. I prepared an answer for both the town and the HPC, which I feel is adequate, appropriate, and timely. It had to be signed by 2 people. It had to be signed by my board chairman, which he did. It also had to be signed by the chairperson of the HPC, who refused to sign it.
Right.
So at that point, I said, I can't be in default, so I changed the answer to being representing the board only, this town board only, and advised the HPC that they were going to be in default if they didn't file an answer, and if they won't sign it, I can't submit it.
What was the reasoning for not signing it?
They don't believe that they've had an adequate opportunity, and I quote, I love this quote, for a real attorney. End of quote. Okay, that just makes my day. I thought I was, after 40 years, I thought I was, but apparently I'm not. So,
I would say that someone needs to put this in as a motion, and then we can further discuss it under discussion. Okay, so if someone would like to put it in as a motion,
I'll make that motion.
do I have a second?
I'll second it.
Discussion.
Okay, that being said, without us giving this Judge Doyle the vote that he's looking from us, who are representing the town of Seneca Falls and all its taxpayers, where does this leave us, that a judge has the authority to tell us how to act on behalf of our constituents that I don't believe is the right way to do it?
well, Attorney Walsh and myself have somewhat made that argument. In a timely fashion, I prepared an answer, filed it, tried to file it, and my hands are tied if a person who is a member of a board refuses. I can't sign a form. So the bottom line is, what I'm left with is representing and making sure that my town is not in default.
Can I say,
Go ahead.
can there be a conflict of interest? I think I emailed Greg on this. Mr. and Mrs. Bovee own property across the street from this building on the corner of Rumsey and Fall Street. I don't know what they intend to do with this property, put a business there, put a house there. Would there be a conflict of interest? Because they might not be wanting to look at this new gas station or whatever it is that wants to go in there if the building is raised.
Dave, I feel that there are multiple conflicts. In this matter, I feel that there are conflicts on that board. I feel there are conflicts on this board.
How do we address them?
Well, Mrs. Bovee, Chris Lytle, member of the board here at HPC, are both members, or both involved with the Preserve Seneca Falls. It's a LLC, of which one of the directors of that corporation is one of our board members here,
Who is?
Mr. Avery. Now, this is all public record. I mean, filing with the Department of State is a public record. And Mr. Avery's not here today, and I don't want to discuss the issue any further in anybody's absence, because I want to afford him the opportunity to speak in his own behalf, and I think he should. But
Can I speak on behalf of a few hundred people that have approached me with a fear we're going to have 3 condemned buildings on Fall Street? Nice and Easy 1, Nice and Easy 2, and Peter Koch's?
I can't disagree with that because I've read Architect Long's report.
Right.
I requested at one point that our town zoning officer weigh in, and I think appropriately Dean said this is way beyond my pay grade. I'll make a decision after I see the facts, but he wants to see the facts. And our town engineers were willing to go out. They were willing to have a structural engineer go out, and the county was going to send a structural engineer to go out. And Mr. Bovee made an application that would have prevented any further review of it pending an appearance before the judge. So,
So what are they afraid of to let engineers in there for then?
one of the things we're going to discuss before the 30th in our phone conversation is I'm asking that the judge has changed his order and said he won't disallow it if the town wants to take whatever police measures it needs to take to review the situation. And I'm asking my board here to direct Dean to carry that out with regard to our own. We have engineers, we can send someone out, and Mr. Walsh, I believe, will certainly cooperate by giving us access. And we need to, at the end of the day, we're taking the long way around the barn to talk about interest before we find out what the interest is in. If the interest is in a non-operative or non-repairable or functionally non-working building, then we're wasting our time, in my opinion. If that is not the case, and that maybe the building, some of these old buildings were built with a lot of talent, maybe it isn't. I don't know. From the architect's report, it sounds like he's an architect, but it sounds to me like the building is structurally challenged. That would be a mild term. So,
From someone that's been in it, that's an understatement. So, I guess that's where we're at.
as far as, I will say to my board this, I'm an officer of this town because under the public officers law, I'm the attorney. I'm an officer of the court because I'm licensed to practice in the state of New York. The court has directed my client to comply, and I encourage my board to comply with an order of the court and do this, show good faith, and I will make the arguments that we've talked about today. I believe we have to deal with conflicts. I believe we have to deal with who is on the board, because two of the members of the board were appointed in 2011. That law died on December 31st of 2013. So technically, the chairperson and another member conceivably are not members of this board. And Mr. Koch has an argument that he was compelled to appear in front of a board that doesn't exist and directed by people who are not, in his view, legitimate members of that board. I think that's a good argument.
I will go along with counsel's suggestion. Can I vote under duress and state my opinion under duress? I don't feel as though a judge on any level has a right to step in when our town attorney is doing everything in the best interest of the town and the board to represent a board, and have a judge from whatever area come in and overstep our process and our procedures to get a result for something.
I presented the separation of powers argument in addressing this with the judge. In essence, saying that a judge has a role to decide cases, but a legislature has a role to legislate and do what it does, and we're in two different arenas here, and one is overlapping the other. The judge, on the other hand, is saying that when people are in front of him, he wants to make sure that everybody is. One of the questions you always hear when you watch television is, do you have counsel here? Yes. Are you satisfied with the services of your counsel? They say yes, and he goes forward. In this case, I think they would, that board would say, no, we're not satisfied with the services of our counsel, and we don't feel we're represented. So when they say that to a judge, the judge looks to get them covered with counsel.
Mr. Forster.
Yes, sir.
And I was going to bring up the branches of government. And, you know, you have the executive, the legislative, and the courts. Generally, courts can overrule legislative action.
Yes, they can.
But they can't order a legislature to vote one way or another. I believe there's case law on that.
There is.
And so I'm stating here now today that I will vote no on this. Now, if someone appeals, if the full board votes not to proceed with hiring an outside attorney, then someone could appeal our legislative action, and then it would be proper to the judge to rule on our legislative action, correct?
Correct. When we argued this point, two cases were brought up that involve, has there ever been an instance of a court ordering a board to be represented at the expense of its parent, the town? Yes. The cases are far, far, far different than what we have here. In those two cases, the town board sued the board, the equivalent of the HPC. They sued their own planning board. So the town sued the planning board to remove the chairperson. The chairperson fought back, went out, got his own counsel, and they won. Their attorney then sued the town for his legal fees. And the court allowed the fees to be reimbursed. Therefore, the court directed the town to pay his legal fees. That's the previous case. On the basis of that, the court is making the argument that it has the authority because it's happened before. In this attorney's opinion, that example, that case, is light years away from this case. We haven't sued anybody. This board, as a board, has not taken any position with regard to the Koch building. This board has not directed the HPC to do or not do anything. This board has not intervened, but we have been sued by an outside third party, Mr. Koch, because he sued the town of Seneca Falls, and he sued a board of Seneca Falls, which is the HPC. Therefore, now we're involved. So I tried to file an answer on behalf of both parties, which I would have done for planning, I would have done for zoning, I would have done for the Board of Assessment Review, I would have done for any employee of the town. So I'm not disqualified. He may put that in his order, and I am appreciative of that. But he's also said that he will allow them to speak with another attorney. And of course they said, well, who's going to pay the bill? And he said, you are. I don't particularly agree with that, but if that is his Honor's pronouncement, I guess we wait and see on Tuesday morning where we're at, but I know Mr. Walsh and I share one issue, which is before we get into the weeds on all this legal stuff, I would very much like to be able to have an answer with regard to what is it that we're being asked to save? What is it that we're being asked to do? And where are the plans where somebody is ready, willing, and able to do something with this building? I don't see any of that. So I'm hoping that this is a very short venture of limited duration, because if it isn't, this is not something that's going to be decided by something locally. And if it has to go further up the chain, then obviously Ms. Marsh is entitled to say, well, I'm doing what I was directed to do, so guess what? The bill comes to us. And so to answer the question from the other night when we all sat here and somebody got up in this very room and said, why isn't the town attorney doing his job? Well, I felt I had done my job, and I was trying to do my job, and I cannot go down there and represent them and tell the judge, I don't care who you appoint, they're my committee and I'm representing them. He's not allowing me to do that. And the board isn't accepting that. So I have little choice but to say, respectfully disagree, but if he orders me to do something as an officer of the court, I have to urge my board to agree to that. I'm disturbed by the conflicts of interest, and they're not just on the HPC board. And it's causing a huge problem in everything that this board does. They have divided interest. The only interest this board should have is town of Seneca Falls business. So,
Is there any more discussion on this matter?
Before you go to court, then, is it feasible to get, say, 3 engineers in there to look at that building before you go to court? Is there a stay that says they can't do that?
The judge, originally there was a stay. Mr. Koch effectively argued to have that portion of the stay dropped. I joined him in that. We are allowed under the police power to go in and examine it, and by hopefully the middle, this happens to be a holiday weekend, by Wednesday I'm hoping that we have 3 guys with hard hats go through the building, and one of whom is our own engineer, probably Pete Baker. I've asked John Condino to come down, go through and ask them. They're professionally licensed people in the state of New York. Are you willing to put your license on the line and say this building is fit for use? If they are, then we'll do what we have to do. If not, then I don't know what else to do. We have to go forward with this on November 30th.
Now with this email that you sent us,
Yes.
and reading through everything I'd seen what the judge said,
Yes.
and a reasonable rate, I think it was like $175 an hour, but can go to $250 an hour.
Correct. And
Am I right on that?
and
It could get raised?
her engagement letter is $250, but however, her letter is written prior to our court appearance, wherein he said, I, as the judge, will monitor these fees. So our agreement here today, where I say, be it resolved, Hancock Esterbrook is duly appointed as counsel solely within this matter, Peter Koch, and further pursuant to the restrictions of the court's oversight of fees, scope, and billing, and that's right in the transcript.
I seen in the transcript it was like $175, and then it kind of contradicted itself and go to $250 an hour.
It's generally, there's a distance between fees outside of court and sometimes inside of court.
Okay.
So, which makes sense. And I trust that Wendy will follow that direction. She has a copy of this transcript. She's, in my opinion, she's a very, I've litigated with her before. She's very competent. She's a good person. She will do what she understands the confines of this.
Okay.
This is not something, gentlemen, that I'm happy about. I'm happy to see that we have a board chair here today.
We all need to understand.
I represented that board in some pretty contentious issues with other members of this board. There's never ever been a problem. Same thing with zoning. And there's a major issue here that has come up that's been uncovered because of this action. And that is an issue which very much concerns me. So we've got difficulties here.
And that is the conflict of interest.
That's the conflict of interest. It's also whether we,
213, 214 law.
if a court were to decide in ruling on this motion that that board doesn't exist, it also rules that our filing didn't exist. If our filing doesn't exist, do I have a planning board? Do I have a zoning board?
Should I swear in now?
Do I have to have everybody redo their oaths of office? Do we have to recreate it? But more importantly, what happens between the time it ended and the time we properly redid it, and everybody in that group says, we're all grandfathered in, there was no law? What do I do about that?
Question I have is, can
Yes,
it
sir.
be held in contempt of court, since it's a directive of the judge if we do not pass this?
The town, that's a drastic remedy, I think. Knowing the particular judge involved, I think he would ask me to explain to my board that he would hope that there would be compliance with his directions.
I got way too many emails.
And I encourage, as an officer of the court and as an officer of the town, I want to, in good faith, try to, I can't serve two masters, but at the same time, I want to, in good faith, show the court that the town will seriously approach this. But I have my own concerns about, we have three branches of government for a reason. And I take that very seriously. And so does the judge. I think the judge is simply trying to get to the point where he can say, look, before I can make a decision, I need everybody in front of me properly represented. Would you please bear with me? Okay? Fair enough.
Okay.
So what do we got to make a motion to?
That's that resolution is here. That's been made and seconded.
Motion made and seconded. I just have one final statement. I think this goes against the separation of powers doctrine, and I will be voting no on this. Not because I feel you are adequate representation. I've seen you represent boards before, and I think even when some boards had some conflicting interests on that, you stayed to the point of the rule of law and policy and procedure. And I think you could continue to do that instead of us expending money on an outside attorney, because this HPC board feels that they need a second opinion. And I think that well, I won't comment on that board's reasoning, so, because that would be conjecture. So, is there any more discussion? Seeing none, we'll go to a vote. All in favor signify by saying aye.
Aye.
All against, nay. Let me make sure that I heard this correctly. So I'm going to ask Nikki to take a roll call.
Okay, Vic?
Yes.
Dave DeLaylis,
Yes.
Lou Farrar,
This goes against everything that I'm going to vote yes under the duress. I want these issues that we said were going to be addressed. I want an engineer in there, and I want to discuss it more. So that being said, I will give my counsel on his recommendation the yes vote to proceed with this.
And I want to say to my board that I very strongly agree with the sentiments expressed here today, and I will endeavor to resolve this whole issue globally. But in doing so, I want to make sure that we get to the root of all these issues, and I think there are things here that need to be reviewed.
This tears me up, doing this.
Well,
This tears me up.
I think, I know that the judge feels my sentiment, and I'm trying to be a good soldier for both
I see that.
of my directors. Okay, a direction that I have is from the court, a direction I have is from this board. I'm trying to satisfy both. I am not happy with the situation that I'm in, but at the same time, I want to stress that we need to go back to the beginning and say, what is it we're trying to do? Which is, let's talk about a building. I think we should have that conversation up front and center, because we're taking the long way around the barn.
I agree.
Okay.
I mean, I went through everything that you emailed us, and I'm voting yes because of what the judge is saying there, but same thing, a little under duress, and I want Wednesday or whenever, as soon as possible, to have engineers in there to find out what's going on with that building.
Agreed, and I spoke about it before our board meeting the other night. I spoke with John Condino. I know Pete Baker has been apprised of it. At one point, at the last court appearance, there was, and I will say this, that there was a meeting scheduled at 2 o'clock that afternoon. The court appearance was in the morning, and there had been a meeting scheduled, arranged by Dean, to have the two engineers, the county and our engineer, appear along with the architect, along with Mr. Walsh's client. The court appearance was called off by the filing of Mr. Bovey's order to show cause.
I just wanted to add as well, I feel that you're competent and capable of representing us, but
Thank
it's an
you.
order of the court. I don't see how we can't do it.
And that's where I'm coming from. I don't have to agree with it, but I have to obey it. So I'm very concerned here that that agreement by Dean to arrange that meeting, to say, let's look first at what we have, was met with a claim ported to me by opposing counsel that this board was trying to thwart the will and the role of the HPC. And that I vehemently deny. There have been no discussions, and I have to say this because I've previously been accused of being in collusion in the Finger Lakes Times by an author, a guest appearance person, of colluding with various members of this board. I have not done so. And I have endeavored to keep all my board members informed. The moment I got pleadings, they got pleadings. I emailed them directly. And the allegation that this board has taken any type of approach in support of Mr. Koch or opposed to the HPC is absolutely false. That has not occurred. And I would like to see a resolution of this by the courts as quickly as possible.
Agreed.
And Mrs. Greer, I did not vote yet.
No, you didn't.
No. Okay, so let's call my name.
Greg Mazzaro.
No. And I will entertain any privilege of the floor, if anyone wants to say anything extra here today. Seeing no one wants to take privilege of the floor, we don't need an executive session, so I'll entertain a motion to adjourn.
Second?
All in favor?
Aye.
We are adjourned.